thank you for joining us for Saul Ewing, Arnstein and Lear's College Athletics Compliance 101 training. Today's training will provide an introduction to athletics governance and compliance issues and review several hot topics, including impermissible benefits, institutional monitoring and control, and head coach responsibilities. You can expect to leave today's session with an overview of the best practices that can be applied to your own athletics programs. My name is Amy Piccola, and I am joined by my partners, Sandy Bilas and Pat Nugent. Sandy, Pat, and I are members of Saul Ewing's higher education practice. Before we begin, there are a few housekeeping announcements that I have to walk you through. First, questions can be submitted through our Q&A tool, which you'll see at the bottom of your screen. We'll do our best to answer all of your questions during the program. If we don't get to you, we'll do our best to follow up after our session ends. Today's program has been approved for CLE credit in Delaware, Florida, Illinois, Minnesota, New Jersey, New York, Pennsylvania, and we have an application pending for credit in Virginia. As a CLE provider, we must be able to verify your attendance. So at random points during our session today, we will display and verbally announce 2 numeric reporting codes that you must record and report back to us using the CLE verification survey that you received in your training reminder email. This survey will also open in your browser automatically at the conclusion of our webinar. We will in turn send you your certificate of attendance once we've received that survey response. Please be sure to respond to the CLE survey with your numeric codes within 5 days of today's program. Early next week, you'll also receive a thank you for participating email that will include access to all training materials associated with today's session. And finally, on the housekeeping front, our legal disclaimer. The provision and receipt of the information in this program, A, is not legal advice, B, does not create a lawyer-client relationship, and C, should not be acted on without first seeking professional counsel who has been informed of your specific facts. Let's begin. To orient us in today's session, I want to walk through today's playbook that will introduce what we intend to cover during our session. First, Sandy will walk us through an introduction to NCAA governance and enforcement, focusing on common violation types in all 3 of our NCAA violation divisions. We'll also cover the most commonly violated rules, at least based on NCAA's reporting and our own analysis. We'll then move into covering those hot topics that we introduced early on in the presentation. First, we'll talk a little bit about impermissible benefits. Second, we'll talk about failure to monitor and lack of institutional control. And finally, Sandy will close us out with head coach responsibilities. To put a bow on today's presentation, we'll discuss best practices for your own compliance programs. And then at that point, address any of those questions that are outstanding. I see that we are potentially dealing with a bit of a PowerPoint. Okay, it looks like we are good to go. Apologies, everyone. So with that, I am happy to turn things over to Sandy, who is going to walk us through our introduction to NCAA governance.
All right, thanks, Amy. And thanks, Mary. You can go on to the next slide for us. So it's good to have you all here today. Thanks for joining us. As Amy said, I'm Sandy Bilas. Nice to see you all, or at least see that you're all here. I'm going to cover first, give a little bit of a background to what's going on in this area, so that you're oriented. And then following me, we're going to dive deeper into some of the really key issues, the hot topics in this area. But first, as the slide says, hopefully you all know that there are 3 NCAA divisions, 1, 2, and 3. And there are many, many, many rules that these divisions have promulgated. Many of them are similar across divisions, but there are some differences. But today we're going to be talking about violations of those rules and what can happen when you violate some of those rules. And the divisions classify their violations in different ways. Division 1 breaks it down into level 1, level 2, and level 3 violations. So for Division 1, that level 1 is going to be a severe breach of conduct. That's what it terms level 1 violation. So these are violations that seriously undermine or threaten the integrity of college sports. They could provide or possibly are intended to provide a substantial or extensive recruiting, competitive, or other advantage, or they involve a substantial or extensive impermissible benefit. So some examples of level 1 violations in D1 include lack of institutional control, academic misconduct, failure to cooperate with the NCAA, unethical conduct, violations by the head coach, payments to recruits, booster involvement in recruiting with member school knowledge, or a collective group of level 2 or level 3 violations can rise to a level 1 violation. Level 2, by contrast, level 1 was severe breach of conduct. Level 2 is significant breach of conduct. So these are violations that provide or are intended to provide more than a minimal, but less than a substantial or extensive recruiting, competitive, or other advantage. They include more than a minimal, but less than a substantial or extensive impermissible benefit. And they could involve conduct that may compromise the integrity of college sports. So examples here can be failure to monitor, systemic violations that do not amount to a lack of institutional control, multiple recruiting, financial aid, or eligibility violations, some violations of head coach responsibility rules, impermissible contact with a student athlete or prospect, or a collective group of level 3 violations can add up to a level 2 violation. And then finally, level 3, which is a breach of conduct. So it's not significant, it's not severe, but it is a breach. So these are violations that are isolated or limited in nature. They provide no more than a minimal recruiting, competitive, or other advantage, or they provide no more than a minimal impermissible benefit. So these can include inadvertent violations that are limited in nature, maybe an extra benefit or financial aid, academic eligibility, or recruiting violations, provided they do not create more than a minimal advantage. So that's Division 1, that's how they break it down. Division 2 and 3 they only use 2 different classifications, secondary and major. I'm going to give you the secondary definition first, even though it seems to come out of order. But a secondary violation, the lower level of violation, is a violation that is isolated or inadvertent in nature. It provides or is intended to provide only a minimal recruiting, competitive, or other advantage, and it does not include any significant impermissible benefit, including but not limited to an extra benefit, recruiting inducement, preferential treatment, or financial aid. That's a secondary. A major is everything else. All violations other than secondary violations are major violations, specifically including those that provide an extensive recruiting or competitive advantage. Multiple secondary violations can also constitute a major violation. So those are the key 2 differences between Division 1 and then Divisions 2 and 3. We have a quick poll that's about to come up. We'd like to know, where are you from? Are you from Division 1, 2, or 3, or some other non-NCAA school? If you could answer the poll, it'd be great to see where everybody's from. And then we'll give the answers in a second. All right, so it looks like the majority of you are from Division 1. Well, welcome. We've got a few from Division 2, several from Division 3, and a few from other schools. Thank you for letting us know. It's good to see you all. So we are going to be focusing on, across the divisions, but a lot of times we'll be speaking directly to Division 1 rules. But know that even when we're talking about a Division 1 rule specifically, there are almost always corollaries in Division 2 and 3 that line up very similarly. So they've got this difference in violation classifications, but really the rules themselves are all fairly similar for the most part. We can move on to the next slide. So let's talk about Division I a little bit more. We've gone through the past couple of years of violations to look at what tends to crop up and where are the trouble spots for schools. And we found that the 5 bylaws that we list here are fairly common when schools violate the Division I rules. So the first one we've got listed there is head coach responsibility. We're actually going to be diving into this one in greater detail. I will be later in this presentation. But in short, this requires a head coach at an institution. They are presumed to be responsible for the actions of all staff members who report directly or indirectly to the head coach. They are required to promote an atmosphere of compliance within their program, and they must monitor the activities of all staff members involved with the program who report to the coach. That is the head coach responsibility requirement. Violations of that requirement can be very, very significant and problematic. Offers and inducements, this bylaw relates to recruiting. So an institution staff member or any representative of its athletics interests shall not be involved directly or indirectly in making arrangements for or giving or offering to give any financial aid or other benefits to a prospective student athlete or their family members or friends other than as expressly permitted by NCAA regulations. There are specific prohibitions, rules about awards, employment, loans, and payment for medical expenses. The next bylaw 19 is failure to cooperate. So this really, this rule also creates the infractions program. All institutional staff members and prospects and student athletes have a responsibility to cooperate with and assist the NCAA enforcement staff. This is a very significant rule. If you have a breach of one of the rules, but you fail to cooperate, that can rapidly cause you to be in bigger problems with the NCAA than you would have been otherwise. Impermissible extra benefit is the next one that's on there. We're also going to be discussing this one in greater detail. This involves awards, benefits, and expenses for enrolled student athletes. So offers and inducements are for recruits. Impermissible extra benefits are for current enrolled student athletes. So they are any special arrangement by an institutional employee or representative of the institution's athletic interests to provide, or a representation of their athletic interests to provide to the student athlete or their family or friends with a benefit not expressly authorized by NCAA legislation. So this can include loans, guarantees of bonds, cars, other transportation, or signing or co-signing a note to arrange a loan. All those things can fall into the impermissible extra benefits rule. And finally, we've got countable athletically related activities. This relates to playtime and practice sessions. So this can include any required activity with an athletics purpose involving student athletes and at the direction of or supervised by one or more of the institution's coaching staff, including strength and coaching and conditioning coaches. They are included. Administrative activities, such as academic meetings or compliance meetings, are not considered countable athletically related activities. Now, voluntary, there's a difference between required and voluntary activities. Voluntary athletically related activities, the definition there is a student athlete must not be required to report back to a coach any information related to the activity, and no staff observer may report back to the coach any information about the activity. They must be initiated and requested solely by the student athlete. Their attendance and participation may not be recorded for purposes of reporting to the coach. And there cannot be any penalties for electing not to participate or any recognition or incentives given based on attendance or performance in the activity. So your football players want to get together in the middle of the quad to throw the ball around for fun. It's them initiating it. They're not going to be rewarded for it. They're not going to be punished for not doing it. That's the kind of voluntary athletically related activity that is not a required one, it's not a countable one. And so you would be avoiding this, violating this law or this rule. You can move on to the next slide, Mary. Here we've got some of the common violations in D2. So I've already talked about head coach responsibility. The rules there are the same, it's just a different bylaw number for D2. We've also got extra benefits. That's the rule about providing benefits to current student athletes. Again, different bylaw, very similar rules. Some of the differences, though, these next three. One is fulfillment of credit hour requirements. So this goes to a student athlete's eligibility for competition. Their good academic standing, right? So a student athlete cannot represent an institution in intercollegiate athletics competition if they are not in good academic standing. This means a minimum GPA requirement and a minimum credit hour requirement. That's a common violation among D2 schools, is to have student athletes representing the institution who are not in good academic standing. 2-year college transfers is another interesting rule that often comes up for D2 schools. This is eligibility for competition under the transfer regulations. So a student who transfers to a member institution from a 2-year college has to complete an academic year of residence unless they meet certain eligibility requirements. This often trips up D2 schools, unfortunately. And then the last one there is the institution's responsibility to certify academic eligibility. Again, this goes to a student athlete's eligibility for competition. An institution shall not permit a student athlete to represent it in intercollegiate athletics competition unless that student athlete meets all applicable eligibility requirements and the institution has certified their eligibility. A violation of this bylaw in which the institution fails to certify is considered an institutional violation, but it doesn't affect the student athlete's eligibility, provided the information needed to certify eligibility was available to the institution and the student athlete otherwise would have been eligible for competition. So there's a little bit of a nuance there where if it's not the student athlete's fault, they really were eligible and they gave all the information necessary to the institution, but the institution failed to certify them as eligible, then it's going to be an institutional problem, not that particular student athlete's problem. We can go on to the next slide now. Now here we are with Division 3. Again, responsibility of head coach. I've talked about that already. Extra benefits, talked about that already. The next four bylaws listed there, I haven't talked about yet. So consistent financial aid, athletics considered as a criterion. This obviously goes to financial aid rules. So here, a member institution shall not, a D3 member institution shall not consider athletics leadership, ability, participation, or performance as a criterion on the formulation of a financial aid package. That's simply what it means. You are not allowed to consider those things when giving financial aid packages to prospective students. The next one, consistent financial aid, clearly distinguishable pattern for student athletes. Again, talking about financial aid, the financial aid package for a particular student athlete or group or team cannot be clearly distinguishable from the general pattern of all financial aid for all recipients at the institution. So they look both at the specific student athlete and they look across everybody to see if they are getting some difference when compared to everybody else. That's how they're going to decide and tell whether or not you violated this law. Again, running into more financial aid bylaws issues. The next one is athletics involvement in financial aid packaging. Members of an athletic staff shall not be permitted to arrange or modify the financial aid package and are prohibited from serving as members of an institution's financial aid committee and from being involved in any manner in the review of the institutional financial assistance to be awarded to a student athlete. They cannot be involved for D3. And finally, academic status goes to eligibility to compete. To be eligible to represent an institution in intercollegiate athletics competition, a student athlete must be enrolled in a minimum full-time program of studies, be in good academic standing, and maintain satisfactory progress toward a degree. Those are the common violations in D1, D2, and D3. And now I'm going to hand it off, I believe, to Pat, who's going to jump in on our next topic. Pat, are you there? And forgive me if it's Amy. Amy, I'm sorry.
Me.
Amy, you're up next.
I was going to say, surprise.
I fumbled the hand up. All right, go ahead, Amy.
Thanks so much, Sandy. So we are going to focus in on impermissible benefits in our section, but what we wanted to do before diving in on our 3 hot topics was just share some excerpts quickly from NCAA reporting, which is really helpful just to put in context here, sort of the expectation that for many of our attendees today, compliance and athletics compliance is not job number 1, and it might not even be job number 15 on the list of tasks we all have to do. And so a common theme as we move through our hot topics in particular, and certainly when we, as I said earlier, put a bow on things to talk about best practices in compliance, is to give you the tools, if you are not living and breathing athletics compliance every day, the tools to understand where you may want to be focusing in your compliance reviews and updates, and help you sort of set some frameworks or checklists for doing so. And so one of the tools that can be really helpful, and for those of you who are attorneys, this should resonate. One of the tools that can be helpful is to look at what other institutions have done. And when doing so, when they have run afoul of NCAA rules, at least in NCAA's own estimation. And Pat is going to walk us through what the infractions and enforcement processes look like a bit later in our session today. So you'll have even more context. But what you see on the screen is really just a screenshot from a report that NCAA puts out on a regular basis that tells us, here's what is happening in collegiate athletics over time and over, sort of subsets of time. So we can really focus in on infractions that are common, penalties that are common responses to those infractions, who on our campuses are trending in perhaps a not ideal way. And you can see that in the bottom left. So again, this is available directly from NCAA. Don't want to spend too much time walking through the details here, but did want to highlight NCAA's efforts through its own enforcement and infractions processes to provide some color and some understanding around what other institutions are doing. So we can move on to the next slide. Again, this is from the same report, which again, as I noted, is updated with some frequency. Here, these numbers are current through almost a year ago, from December of 2020, but you can see what it is that enforcement staff at NCAA is engaged in, and what those numbers look like. So again, just some color, really to highlight for those of you who aren't doing this on a day-to-day basis, a really nice resource for you when you're sitting down and you're looking at sort of the vast expanse of the rules, as Sandy identified, where we may want to tighten up, where we may want to do those internal audits. It's nice to go back and look at and hear directly from NCAA. This is where we're focused, and here are the outcomes of that focus. So with that, we can move on. And we are going to really dig in on our hot topics, at least hot topics as, again, not only identified by us, but as identified by the NCAA itself. So you heard from Sandy when he was setting the stage for us in the common violations section of the presentation, that in each of our 3 divisions, we've historically seen a trend around impermissible extra benefits being a common violation. As I noted, this is true in all 3 of our divisions. If you were to hold up the bylaws side by side, you would see that there are real similarities. In fact, these happen to be segments of the bylaws that are nearly identical across the divisions. So when we're talking about impermissible benefits, we're really talking about a pretty broad category, as Sandy identified for us. This broad category includes, as I mentioned, extra benefits, which we will talk about. It can include inducements for prospective student athletes, and sort of broadly, and I think really interestingly, because it's easy to think about cash payments or airline tickets or even that bag of groceries we have here in our clip art, but it can include preferential treatment. And so we'll give you a fact pattern that sort of represents that aspect of impermissible benefits as well. So let's take a step back or a pause and take a look at exactly what we're talking about by looking at our bylaw. Extra benefits. This is really where our focus, again, especially for those of you who are new or infrequent visitors to athletics compliance. Extra benefits are defined, and again, defined across our divisions as any special arrangement made by an institution employee. So this could be our athletic staff, our coaches, or somebody outside of our athletics department, or a representative of the institution's athletic interest. Most commonly, and really by definition, these are going to be our boosters. And I did not, but I probably could have underlined and put asterisks around boosters for those of you who are thinking about where do I start, what should I focus on. My personal recommendation is to always include our relationships with boosters on those compliance checklists. So extra benefits are these special arrangements that are provided to a student athlete or a student athlete's family member or friend. So that's important to remember here as well, that we're not just looking at the relationship between the institution or a booster or someone acting on behalf of the institution and the student athlete, but also sort of the entire universe that circles around the student athlete. And what is an extra benefit? Well, it's a benefit that is either not generally available to other students and their relatives and their friends, or is not otherwise expressly authorized by NCAA legislation. So this is another place where for those of you who are participating today and I've worked with before, this will sound very familiar, perhaps not in the athletics context, but certainly in some of our other student conduct spaces. Know thy policies, know thy rules, know the NCAA bylaws. And as Sandy, again, suggested to us, the rules are dense. And even when we're talking about a fairly narrow universe here, extra benefits, there are a lot of nuances and sort of issues around the fringes where it's, this is allowed up to this amount, or this is okay under these circumstances, but not those. So a real familiarity with these rules is important for purposes of today's presentation, and certainly out of respect for time. We aren't going to trade in nuance today. We're going to speak high level, but I did want to just remind us all that as when we're talking about impermissible benefits and our definition of extra benefits in particular, that some conversancy with the way these rules intersect is going to be necessary when we're doing our compliance checks. So with that, let's move on to start talking about examples. What does this mean in real life? So I suggested before that boosters are always on my compliance list. These examples are examples that are commonly given to boosters in sort of the please do not do or provide these things to student athletes. Again, with some nuance, with some characterization around some of these things in particular. But while these examples are on the screen and are generally speaking booster focused, it's worth focusing on what our institution employees, so our coaches, our staff, anyone outside of the athletics department. It is an extra benefit, almost by definition, to provide cash to our student athletes. We'll see an example or two of that coming up in a few minutes. Cost-free goods or services. Special discounts. So this one is important. So whether it's a booster providing a special discount to their own enterprise, right? So many of our boosters are community members. I hate to use this example because it almost sounds trite, but it's the local car dealer who's very engaged with our athletics program. Are they giving special discounts to our student athletes only? But it can also be sort of external relationships. Are we setting up relationships for our student athletes to access discounts or special credit that is not also being provided to our entire student body or particular cohorts of our student body within which our student athlete may sit? So a good example is, international students get this benefit. This student athlete happens to be an international student also. So if they access that benefit because they check those boxes, that's okay. It's otherwise broadly available. Transportation is one to highlight because I think it's a good example of what we talked about on the last slide, which is that a familiarity with the nuance will be important. Certain transportation in connection to games or practice, okay. When we start straying or hit certain other characteristics, which we'll also see in just a few slides, not okay. But broadly speaking here, we're talking about provision of transportation, particularly by a booster who comes along and says, hey, soccer player, happy to give you rides or arrange for Uber whenever you want it to take you wherever you want, whenever you want. Those are the types of things we're looking out for here. This is a good time before we move on to just take a beat and reference the Supreme Court's decision from earlier this year in the Alston matter. And the reason it's important to take a beat, or it's worthwhile to take a beat and talk, is because the Alston decision, for those of you who had some time to sit and read the language, or perhaps are even familiar with the history of the case as it moved its way through the district and appeals courts, also focused on benefits. In that case, the primary issue, or at least the issue that wound its way up to the Supreme Court, dealt with education-related benefits in particular. So these are the benefits that we can draw a line between the educational or student experience of our athletes and the provision of the benefits. So this might be providing computers, it might be musical instruments for participation in a music program, internship opportunities, study abroad opportunities, those types of things. Again, not expressly defined other than to say we have to be able to draw a line to the educational experience. So one, just wanted to bring this up here because of the use of the word benefit in both of these contexts, but also important to know that the Supreme Court told us, or instructed, that NCAA getting involved in prohibiting or limiting the provision of education-related benefits to our student athletes in a way that is different than similar benefits may be provided to non-student athletes, in the broadest of terms, not permissible. Just last month, SEC announced that its member institutions are permitted to allow education-related benefits up to the maximum that had been previously defined of just shy of $6,000 per student per year. So not the time to get into the weeds, but did want to make reference because of the Alston decision for anyone who is butting up against athletics issues sort of looms large in this space. So these are some examples back on our extra benefits, not okay with very limited exceptions rules. Let's move on to start putting some color around why it's important to think about our prohibitions and our rules and sort of the impacts of this on our campus. And we can go to the next slide here. Great, thank you, Mary. Some common themes, and when we reference common themes throughout these next couple of segments of our presentation, what we're talking about are those common themes that are available to us through review of either NCAA reporting or review of NCAA infraction and enforcement decisions, which are publicly available in more cases than not. A really common fact pattern, which won't surprise you based on what we've heard, both of the definition of extra benefit and some of the examples, is a coach who provides cash. Hey, go out there and stock up your fridge with meals for the next couple of weeks, or other impermissible benefits as sort of a way to support their team. And you'll often hear, because the NCAA often hears, I didn't know that this was against the rules. And I think we'll hear a little bit from Pat around sort of the ways that NCAA responds to that type of argument from coaches in particular. But we'll dive in a little bit more on some fact patterns, but just to give you thematically where this often comes up. We won't spend a lot of time walking through each of these bylaws because Sandy has already set the table for us at the beginning of our session. But what I did want to highlight before talking about some specific fact patterns, and what really resonates for me when I look at the bylaws that are commonly implicated in our outcomes related around extra benefits or impermissible benefits violation, is really that it goes beyond bylaw 16, which, if you were to pick up any of your 3 manuals, is the bylaw that really puts definitions around permissible and impermissible. So that's the rule that's going to hold most of that nuance I've referenced here. But we're really thinking about these rules and the bylaws as interlocking, meaning one fact pattern, which I can look at through the lens of impermissible extra benefits, often implicates multiple aspects of our obligations under the NCAA bylaw structure. So to highlight just a couple of these, and again, Sandy has introduced them in more depth, unethical conduct. The unethical conduct bylaw includes or incorporates as one of the listed exemplars of unethical conduct is offering or providing extra benefits to student athletes or prospective student athletes. So not only are you violating bylaw 16 by providing an impermissible benefit, but you've now engaged in unethical conduct, whether that's you as an individual coach or athletics department staff member, or you're an institution who has failed to monitor and comply with this rule by allowing sort of this environment of non-compliance to exist in your department. Head coach responsibility, which we'll hear about from Sandy, has the head coach sort of, again, allowed an environment to grow up in their athletics department that sees staff members, coaches, assistant coaches, or others in a particular team or in the department writ large provide these extra benefits sort of unmonitored. And also, as we've just sort of teed up the Alston decision, or lightly teed up the Alston decision, amateurism, while it is on shaky ground in some respects in the intercollegiate context, is still intact when we talk about the express prohibition on inducements. So any sort of payment or provision of benefits for the purpose of enticing a prospect to enroll in our institution, enroll in our athletics program, or pay for play. So your athletics accomplishments are so fantastic, I'm going to write you a check or give you this new car, right? And so those types of things are still prohibited. So there are circumstances, and it's not every time, but there are circumstances when our extra benefits or impermissible benefits rules are implicated that also start to shade into our amateurism rules. So with that, let's just talk quickly before turning things over about what happens or what may happen if we as an institution are dealing with an impermissible benefits situation. Again, this is common. So this is us looking at history and reported public outcomes from infractions and enforcement proceedings. Both the institution and the coach, although coach can be subbed in for sometime an assistant athletic director and athletic director others. But these are sort of the import, the why do we care? And you'll see a common theme as we start talking about our other hot topics and the outcome. It may be that, to use the example here of a coach, it may be that the coach is the one who is on the side making impermissible payments to a student athlete. But what have we as an institution done to either prevent that from happening, report out, or on the sort of negative side of things, what did we not do when we should have done something when we've learned about this type of behavior? So the institution is going to be held responsible for the actions of its employees and its boosters, or for those of us that don't employ our athletic staff, those who are in those positions in our athletics department. The fines tend not to be terribly significant in the grand scheme of things. Several $1,000s, but typically, not always, but typically not much more. What really impacts us are sort of the PR effects. We can see if we allowed ineligible students to participate, which, just to put a finer point on that, a student athlete who accepts an impermissible benefit is in violation, of course, of our bylaws, as we just saw. And that student's eligibility to participate in athletic competition is in immediate jeopardy. We have obligations to report out, and Pat will talk a little bit more about the institutional control aspect of things. But a student athlete is ineligible if they have violated these rules. So play that out. We as an institution allow a student who is now ineligible because they have violated our extra benefits, our impermissible benefits rules. We then may have benefited from that student's participation by winning games. We may have won our conference. We may have won a tournament. It is not uncommon as a penalty for NCAA to look back at what has happened over the course of time during which a student athlete was impermissibly receiving benefits or receiving impermissible benefits, to vacate records of the program and to vacate records of that individual student. So, the top scoring record, for example. We may be subject to recruiting restrictions. So this is not let's clean up this mess, but going forward, there may be limits or stricter parameters around our recruiting. And then probation. Probation is sort of the classic compliance outcome here. We are going to be under the even more watchful eye of NCAA. We are going to be publicly censured. So usually in the form of the release of the outcome of our decision. So anyone like Sandy, Pat, and I can pick up the outcome, read all about the things that happen, and then hopefully derive some lessons learned, not just for that institution, but for others. The coaches will also have sort of coextensive and similar impermissible benefits penalties. Show cause order is typically going to be the outcome. So this is going to require not only additional monitoring of the coach, but it's going to put limits around their ability to be employed or to be involved in intercollegiate athletics, depending on sort of the specific contours of that order. So with that, I'd just like to move on and relatively quickly just highlight some case studies. But before doing so, the long-awaited CLE code number 1. That code is 58321. Again, for those of you who are following along in an effort to obtain CLE credit, your CLE code is on the screen and will be on the screen for the next few moments. That code is 58321. Please remember to jot that down and submit that to us along with CLE code number 2, which will be headed your way just a bit later in the presentation to ensure that you're getting your CLE credit for today's presentation. So really high level, I just wanted to walk through 4 examples that, rather than get into the weeds of the process, and that you will hear from Pat what this all looks like when we get involved in the infractions process, but really to demonstrate the breadth of impermissible benefits violations. I thought these were nice examples. They're also nice examples because they cross divisions. So while most of our attendees today are D1 schools, those of you in D2 and D3, you can also learn, because these are without boundaries, the types of violations we're seeing. So the University of Akron and the Baylor University outcomes are actually outcomes that were published by NCAA just this past August. So they are certainly timely, and they are, I think, indicative of the common theme. Is a common theme, not just when we prepared these materials and started pouring through NCAA's last report on its own enforcement trends, but these are sort of up to date. University of Akron, really the example here is sort of the classic, right? An assistant athletic director was giving cash loans from his own personal bank account to football players at the institution, and was doing so over the course of two academic years. The reasoning that the coach gave was, I didn't know this was a violation because, one, it was a loan. I wasn't just making a payment to these athletes, but 2, I did so for sort of out of pure intentions. I gave these loans to these 9 students because they hadn't yet received their living allowance scholarships, their Pell Grants, the source of financial support from the institution. The problem for the coach here is that, 1, good intentions aside, it is a violation of NCAA rule. He was explicitly directed by the bursar at the university that the monies wouldn't be fast tracked, and everybody just sort of had to wait. There were issues around the loan documentation as sort of indicative of perhaps an understanding that this relationship was not within the scope of NCAA rules. I share this example with you only because of this sort of classic. This is not a direct cash payment with no intention of getting that money back, and that this is part of what the athletics director was saying, is that this wasn't permanent. I was going to be repaid. Nonetheless, the university was fined $5,000 and was put on 2 years of probation. The director himself was also was given a 2-year show cause notice. So it did not matter much that the intentions were, at least as stated, good. And it did not matter much that this wasn't a sort of permanent state. It wasn't a cash payment, again, that was not intended to be returned. The Baylor example, as I said, is also an example of a decision or an outcome that's relatively recent. The context for this outcome, and we're just going to focus in on the impermissible benefits piece of things, will sound familiar. This is part of the NCAA process that circled around the institution's alleged efforts to shield football players from disciplinary processes at the institution, and a broad failure to report allegations of sexual and interpersonal violence. So that is the ecosystem in which this impermissible benefits angle comes up. And the reason why I wanted to highlight this example in particular is because it's sort of an interesting take on impermissible benefits, not because it's not clearly a violation of the rule, but rather because it's very easy to think about impermissible benefits in sort of the tangibles, right? Those cash payments, the extra meals, the cars, the discounts, which feel a little bit more tangible than what happened here. In this particular case, we were talking about a football player who had been through a conduct process related to academics on campus and was set out with an academic improvement plan that, should all of the steps in that plan be satisfied, he would be reinstated as a student athlete at the institution. So pretty clear cut, great. Unfortunately, he did not correct his academic behaviors and was caught cheating on a test. The professor or faculty member involved decided that this was not an infraction that they were going to run through the internal academic honor process. But nonetheless, athletics administrators were aware that this student was alleged to have cheated, found to have cheated, and in doing so violated this academic progress plan that had been put in place. Rather than make the report to the president's office, who oversaw the reinstatement or potential reinstatement and academic improvement for this student, kept it to themselves. They didn't report it. They didn't disclose information that they knew would prohibit this student athlete, this football player, from being able to participate in athletics at the institution. This arose again in sort of a messy context, but I think this is really interesting because this sort of speaks back to the preferential treatment as an impermissible benefit. Other students weren't sort of having academic conduct issues swept under the rug, so NCAA would say. Instead, it was by the very nature of this individual being a student athlete, an awareness on the athletics administration's part that if these cheating violations were reported out, this student athlete would not be reinstated. They kept it to themselves. That was deemed an impermissible benefit, in addition to being a violation of other NCAA rules. And just to quickly close things out, the Wilmington University and UMHB examples are, on the one hand, a classic example, and a example on the UMHB part that sort of sounds like, really, that's it? That's all that was required for NCAA to come knocking and determine that an institution and a coaching staff had run afoul of rules. On the Wilmington University piece of things, we had a coach who knowingly, actively provided nearly $3,000 worth of extra benefits to student athletes, ranging from cash, which was stated for the purpose of, pay gas money, meals. I want you to be able to come to practice, so I'm going to help facilitate that by giving you a little extra money, money to pay for transportation services to get to and from the site of practice, but also to help facilitate what really was a commuter situation, some money to help student athletes pay for that, but also things like a camera, perfume, again, talk about tangible gifts. Here, this coach actively not only gave these benefits, but did so by saying, like, look, I'm going to get in trouble. You're going to get in trouble if you tell anyone that you're accepting this stuff. So keep it quiet. So this is sort of the more egregious example of impermissible benefits. The coach went on to declined to participate with enforcement staff, and wound up suffering the consequences of a 5-year no show cause order. The institution was put on 1 year of probation, was fined $5,000, and many of the years in which these student athletes were participated, their individual records were vacated, as were the university's athletics records for that program. The UMHB example on the other end of the spectrum, a football staff started interacting with a high school student, so a prospective student athlete, and gave this individual a few rides to and from an after-school job. Later, this student moves into student athlete territory. They enroll at the university, become a member of the football team. And over the course of a couple of years, the head coach for the football program allowed this student for free to use the coach's car for whatever purposes the student deemed necessary, maintained insurance on the car, at least allegedly for the purpose of allowing the student to continue to use it, and allowed this relationship of, sort of take this car whenever you need to continue until ultimately the student borrowed it one last time and the car broke down. So here, the good news for the university was that the faculty rep, her antenna went off in some conversations and said, you know what, it may seem incidental, but this is absolutely a violation of the rule. UMHB ended up working and coordinating with enforcement staff, came to work through a conciliation process, which I think we may hear a little bit about from Pat in terms of the precedential value of this particular example. The reason I share it with you is only because we've really see a real spectrum here, right? We sort of see this, is that it type violation, to the most egregious, I am actively violating a rule and telling you not to tell anyone because we're all going to get in trouble and we're all going to go down with this ship. So good examples, real life examples. And with that, I'd love to turn things over to Pat to work us through institutional control and give us a little bit more insight into how infractions processes work through the NCAA.
Well, thank you so much, Amy, and hello, everybody. I'm going to focus on the concepts of lack of institutional control and failure to monitor under the NCAA's rules. I'll start with some basic concepts and distinctions, and then walk through a few sample infractions decisions to help illustrate the concepts. Next slide, please. Let's begin by looking at the foundational rules dealing with institutional control and monitoring. These two rules that you see on the slide are the same across all three NCAA divisions. And the first one, section 2.1.1, contains the basic responsibility of NCAA member institutions to control their athletics programs in compliance with NCAA's rules. And not only is an institution responsible for the actions of its staff members, but also for the actions of any other individual or organization engaged in activities promoting the athletics interests of the institution. And you heard about boosters earlier as a prime example. In fulfilling this responsibility, an institution shall monitor its programs to ensure compliance and to identify and report compliance violations to the NCAA. That's Rule 2.8.1, and that's the duty to monitor. So to summarize these rules together, institutions have a general obligation to control their athletics programs, comply with NCAA rules and regulations, monitor the programs, and then cooperate fully with the NCAA. Next slide, please, Mary. You'll see that we have a chart here breaking down some of the differences between situations involving a failure to monitor versus a lack of institutional control, with less egregious, more limited violations falling within the failure to monitor, and more egregious and widespread inadequacies falling under a lack of institutional control. Let's dig a little deeper into these concepts to set the table. Now, according to a white paper prepared by the NCAA's Committee on Infractions called Principles of Institutional Control, the touchstone for determining whether there was a lack of institutional control when a violation occurs is first identifying the institutional policies and procedures in place at the time, and then determining whether those policies and procedures, if adequate, were being monitored and enforced. In a case where proper procedures exist and are appropriately enforced, especially when they result in the prompt detection, investigation, and reporting of violations, there may be no lack of institutional control, although the individuals involved may be held responsible. When proper institutional procedures exist, the NCAA uses a practical, common sense approach to determine whether procedures are adequately monitored and enforced by persons in control. Of course, overall institutional control is exercised by an institution's president or chancellor, but it's rare that the president or chancellor will be making day-to-day decisions specifically affecting the operations of the athletics program. Instead, day-to-day duties of operation, including compliance with NCAA rules, are delegated. And the specific obligations delegated should be in writing and not merely an understanding among senior officials and the athletics department. And not only the athletics director, other officials in the athletics department, faculty athletics representative, the head coaches, and other institutional administrators outside of the athletics department responsible for certification are expected to assume a primary role in ensuring compliance. And these individuals will be assumed to be operating on behalf of the institution with respect to those responsibilities that are logically within the scope of their positions. And their failure to control those matters so as to prevent violations could be considered a lack of institutional control. What are some examples of a lack of institutional control? Well, they would include a person with compliance responsibilities who does not take steps to alter the system of compliance when there are indications it isn't working. A supervisor with overall responsibility for compliance and assigning duties to subordinates so divides the responsibilities that, as a practical matter, no one is or appears to be directly in charge. Or the institution fails to make clear that any individual involved in the athletics program has a duty to report any perceived violations of NCAA rules and can do so without fear of reprisal. And then switching gears for a moment, the failure to monitor. Of course, an institution can't be expected to control the actions of every individual who is in some way connected with its athletics program. So the principles of institutional control make clear that the violation of a rule by an individual who is not in charge of compliance with the rules violated will not be considered a lack of institutional control if adequate compliance measures exist, if they're appropriately conveyed to those who need to be aware of them, if they're monitored to ensure that they're being followed, and if on learning that a violation has occurred, the institution takes prompt action. Mary, could you advance the next slide, please? So here is a list of resources to review in order to gain a better understanding of institutional control and monitoring. And we'll take a closer look at these now. The NCAA Enforcement Charging Guidelines, Committee on Infractions Case Precedent, and Infractions Appeals Committee Case Precedent. Next slide, please. Okay, so the NCAA Enforcement Charging Guidelines. These are the guidelines enforcement considers when determining whether to bring allegations of institutional control, failure to monitor, head coach control, ethical conduct, and so on. Codify existing practices and allow institutions to make informed decisions about their athletic operations. Next slide, please. In determining whether a violation of NCAA rules reflects a lack of institutional control, enforcement staff determines whether the institution's efforts to comply with the NCAA bylaws were in place at the time of the alleged violation, if they were established to deter violations and not merely to discover them after they've occurred, and if they were adequately promoted, monitored, and enforced. There's no presumption of a lack of institutional control, even if multiple violations occur within a case. Enforcement considers the nature and the scope of the violations and the institution's specific efforts to create a positive culture of compliance. Next slide, please. Enforcement staff consider the following non-exhaustive list of factors to help determine the level of institutional control. So first, whether a culture of compliance is promoted through clear communication of the obligation to report potential violations without fear of reprisal. Second, whether there is oversight of the compliance program with respect to its implementation and effectiveness. Third, whether there are written policies and procedures that effectively deter, prevent, and detect violations that are communicated and readily available to all staff with compliance responsibilities. Fourth, whether regular rules, education, and training is provided to student athletes, staff members, and third parties who interact with the athletics department. Fifth, whether there's evidence of due diligence in delegating authority to athletics compliance staff members who are appropriately supported to fulfill their obligations. Sixth, whether program monitoring and review occurs according to established policies and procedures, and whether there's heightened monitoring of individuals known to have engaged in prior non-compliant conduct. 7, whether there's enforcement of NCAA legislation through timely investigation and corrective action when non-compliance occurs, including prompt reporting to the NCAA and taking reasonable steps to prevent similar non-compliant conduct. And 8, whether the institution conducts periodic assessments to determine risks relating to NCAA compliance matters and implements controls to mitigate identified risks. Next slide, please. Okay. Before we take a look at some cases to illustrate some of the concepts we've been examining, let's orient ourselves to the different types of NCAA case precedent and the basic questions we should keep in the back of our minds. What is case precedent? Well, we're looking at hearings decisions with the most precedential value, summary disposition reports, some precedential value, negotiated resolutions, which don't carry precedential value. And we're asking ourselves, are there cases that support our position, cases that contradict our position? Does the Committee on Infractions make any broad definitional clarifications? Or does the Infractions Appeals Committee clarify any of the Committee on Infractions decisions? Those are the questions we're always keeping in the back of our minds. Next slide, please. Included on the slide, forgive the small text here, are 3 relatively recent cases involving an alleged lack of institutional control within D1 institutions. And as the excerpts for the Alabama A&M and University of Mississippi cases indicate, factors suggesting a lack of institutional control may include widespread lack of experience, rules education, and training to conduct certification, resulting in large numbers of student athletes competing and receiving travel expenses while ineligible. In the recruiting process, failing to confirm where prospects are staying when visiting campus, failing to ensure that recruiting rules are being followed, and failing to ensure that paperwork is completed accurately. The Mississippi case is notable in that the committee panel found the school fostered an unconstrained booster culture that contributed to the school's lack of control over its athletics programs, particularly with respect to recruiting. By contrast, in the Savannah State case, where the committee did not find a lack of institutional control, the panel emphasized that despite the weaknesses in the university's eligibility certification program, the vast majority of student athletes were properly certified during the 5-year period at issue in this case. And in that case, the university and enforcement staff attributed the certification violations and the resultant failure to monitor to several factors, the most significant of which was frequent turnover of staff involved in the certification process. The turnover resulted in a lack of understanding of academic certification and inadequate communication among the staff members who were involved in that certification process. Given that the underlying violations were limited in scope, the panel concluded that SSU failed to monitor rather than lacked institutional control. Next slide, please. Let's switch gears slightly and focus on cases involving failure to monitor specifically. This first one involves impermissible benefits, which Amy discussed, and comes in the form of a negotiated resolution last year involving Ohio University. And while negotiated resolutions don't carry precedential value, they still have instructive value for us and are certainly worth considering in assessing your own operations. In this case, the head women's volleyball coach simply misunderstood the applicable rules. Airfare was mentioned to compliance staff during a discussion. Compliance staff knew this was impermissible and they approached the coach. The coach didn't know that paying for parents' airfare was impermissible, and the coach promptly revealed that the program had engaged in this practice numerous times over the years. Both the institution and the coach self-reported, and they engaged in a collaborative investigation with the NCAA's enforcement staff. Next slide, please. The institution and enforcement staff agreed that the violations were inadvertent. The institution did not provide sufficient NCAA rules education regarding official paid visits to staff members responsible for approving expenses. And prior to the discovery of the violations, the staff members did not review recruiting expense reports for the purpose of NCAA compliance. Furthermore, the form that was used to track and monitor official paid visits didn't provide enough information on travel expenses for the institution to determine if official paid visits were compliant or not. Next slide, please. Even though the coach's mistake was inadvertent and the result of a misunderstanding, the institution was still held responsible for failing to properly train athletic staff and failing to have adequate safeguards and monitoring processes in place to catch violations before they occur. And you can see here that the NCAA imposed penalties for both the institution and the coach. Now we'll introduce a quick poll. Chris, if you could launch that for us. Thank you so much. This should just pop up on all of your screens. If you could please take a moment to answer this poll question if you're able, that would be great. And Chris can display our results in just a moment. Okay, we have a whole distribution here. Recruiting restrictions is our winner among this crew. Probation and reputational harm actually comes in third. Monetary fine comes in second place. But with all of these, it just underscores the importance of compliance and avoiding issues surrounding institutional control and monitoring specifically. All right, our next slide, please. Thank you. Now, this example comes from Division 3 and involves failure to monitor and the financial aid awarding process. As you all, I think, know, and as you heard today, Division 3 rules don't permit financial aid packages for student athletes to be clearly distinguishable from the general pattern of financial aid for all recipients at school. Here, Emmanuel College and enforcement staff agreed that Emmanuel violated financial aid legislation when it awarded financial aid at a disproportionate rate to incoming student athletes. The student athletes received additional aid if they were successful in an unpublished financial aid appeals process. The appeals process was open to all students, but coaches were informing prospects about it, which resulted in a large group of student athletes using that unpublished process to obtain additional aid. Next slide, please. The decision states that Emmanuel didn't prevent, identify, or detect the financial aid violations in part due to inadequate rules education. And although the financial aid office had a general awareness of D3 financial aid legislation, no athletic scholarships, no awards based on student athlete status. No one from the athletics department had educated the financial aid office on the more specific rules. And as a result, the institution did not monitor the percentage of students versus student athletes appealing and then being awarded additional financial aid. Next slide, please. The violations were deemed major because they were not isolated. They provided or were intended to provide more than a minimal recruiting advantage, and they included more than a minimal impermissible financial aid benefit. And perhaps most of all, were directly contrary to the fundamental D3 philosophy. Financial aid may not be based in any way on athletics criteria. Nevertheless, the committee did recognize mitigating factors in Emmanuel's cooperation throughout the process when assessing penalties. And we'll see here our penalty summary displayed. And it's all the standard things that you've heard about today. So we'll just go ahead and move on to our next slide, please. All right, let's turn now briefly to a very recent public infractions decision involving failure to monitor with respect to an international prospect living and training near an institution for a couple of months prior to enrollment. Sandy will cover this in more detail shortly with respect to head coaching issues. Focus for now on the failure to monitor aspect. For context though, the head coach failed to monitor the program by providing or having knowledge of violations, failing to report impermissible conduct, and failing to ensure that the prospect's presence near campus complied with NCAA rules. In addition, compliance staff performed insufficient follow-up and fact gathering after learning of the prospect's presence on campus and participation in practice. The committee found that multiple violations demonstrated a failure to monitor the women's cross country and track and field programs. Next slide, please. And Sandy will cover penalties imposed on the head coach, but turning to the principal penalties imposed at the institutional level, we have this list here again. It's all the things you heard from Amy and Sandy about reprimand, probation, fine of $5,000 plus 1% of women's cross country and track and field budgets, fees and bans, scholarship reductions, recruiting restrictions, and vacation of records. Our next slide, please. Okay, so we went through a lot of that quickly because I know we only have 15 minutes and we have more material to cover. We'll talk more about best practices at the end. Here on the slide, we just wanted to sort of outline a few best practices for your consideration. And maybe it's best to just sort of look through those when we circulate our materials. But with that, and with many thanks for your attention, I will now pass our virtual torch back over to Sandy to discuss head coaching responsibilities. Sandy, take it away.
All right, thanks, Pat. So we're going to move on to our last deep key topic here, the responsibility of head coach. We do have one last poll for everybody. If you can put that up for us, Chris. So how does your institution ensure that head coaches are complying with NCAA rules and regulations? Do they regularly check in with compliance staff and receive regular training on NCAA rules and regulations? Do they receive some training, but it's not mandatory? Did they check in only when issues arise, or do you have no clue? What's your answer? All right, got a few no clues, got a few ones in the first answer. This is really, really important. It's really important to your institution, but also it's really important for your coaches. This is how they can lose their jobs, unfortunately. It's not just how they perform, how their teams perform out on the field. It's also how they perform when it comes to compliance. Let's move on to the next slide, Mary. All right, here is the rule. Here's the rule that they need to follow. They are presumed to be responsible for the actions of all staff members who report directly or indirectly to them. Now, they can rebut this presumption by, if something goes wrong, by demonstrating that they promoted an atmosphere for compliance. Right? So they are required to promote an atmosphere for compliance within their program and must monitor the activities of all staff members involved in the program who report to the coach. So how are they going to do that? How do they promote an atmosphere of compliance? It comes down to communications that they send out, monitoring efforts, and other activities that demonstrate their commitment to compliance. So they have to demonstrate that compliance is a shared responsibility by establishing the clear expectation that all coaches, staff members, and student athletes will understand and comply with NCAA rules. They have to demonstrate that the ultimate responsibility for the integrity of the program rests with them, the head coach, including staff actions that reflect on the head coach and violations that result in, including that violations will result in discipline. They have to establish a program that includes immediate reporting of actual and potential issues to the compliance staff and allows for an independent inquiry into those issues. They have to have timely, consistent, and continuing education of all coaches, staff members, and student athletes as to the rules and regulations with written agendas and documentation of the subjects covered and issues discussed. They have to have or show a history of consulting with compliance staff on a regular basis and asking before acting. What's really important here? Documentation. If you can document, if your head coach can document meetings with the AD, with the compliance staff, with coaching staff to talk about compliance issues, procedures, documenting their procedures for monitoring and submitting documentation of specific areas of compliance, reports to compliance of NCAA rules issues, monitoring efforts to ensure that staff and student athletes are complying in a timely manner with the rules and compliance obligations, and ensuring that assistant coaches and others are submitting their required forms. That is how they are going to demonstrate this. That is how, if something goes wrong, they can rebut the presumption of responsibility for what happened. So let's talk about two situations where this went wrong. Let's go on to the next slide. So first, I'm going to talk about Clarion, University of Pennsylvania. This is a D2 school. This is an action that was published in March of this year. It involves financial aid violations within the women's soccer program, as well as a head coach responsibility violation. So here, Clarion hired its head coach to lead its women's soccer program. The coach was given a budget, met with the AD to ensure that he was aware of the allotted amount of aid available and how many equivalencies could be awarded. They had a process that included checks and balances to ensure that everybody, all the head coaches, the AD, the VP of Student Affairs, all signed the agreed upon aid budgets. So they had the right things in place, but the head coach went awry. In 2017 and 2018, he sent letters to 9 prospects promising multiple years of athletics aid, despite the rules that limit aid agreements to 1-year terms. He admitted later, knowing that these letters would not serve as the official athletics aid award and that he sent them with the intent of securing their enrollment. They all signed their letters, but he withheld them from the appropriate officials at the institution. He then, in April and August of 2018, he signed and issued athletics aid agreements to 10 incoming and current student athletes without first obtaining the required signature of the school's director of financial aid. He knew the process, but he chose to circumvent it because the amounts he was offering were in excess of his budget. He withheld the documents from the school. He contacted the students directly later to say he wouldn't have the promised amount of aid and said they're going to have to sign new aid agreements to have their 2018-2019 aid distributed in spring 2019. He did all of this on his own without getting the right signatures. Let's move on to the next slide. So in January 2019, it all falls out. He meets with the AD to tell her of the aid that he had promised to these student athletes that was in excess of the institution's budget. The institution's representatives then had to meet with each student athlete and their parents and revise their financial aid agreements to honor, they did honor the head coach's promises, but he was terminated. His contract was not renewed after February 2019. Clarion then did the right thing. They self-reported these violations to the NCAA in May 2019. 10 months later, the enforcement staff issued a notice of inquiry and started investigating it. Went through a cooperative summary disposition process, which is one of the potential processes that this can go through. Everybody agreed on what the facts and the violations were. And then the NCAA Division II Committee on Infractions imposed additional penalties on Clarion and a show cause order on the head coach, which they accepted. Everybody agreed the violations were major and that his direct involvement in the violations demonstrated that he had failed to promote an atmosphere for compliance and violated the head coach responsibility legislation. He agreed he couldn't rebut the presumption. So this is a situation where his direct involvement means he's pretty much done. So we see that he was let go. They honored the academic aid that he had promised, and we can move on to the next slide. So just one thing about the penalties here. They have this review of their policies and procedures. That's called a compliance blueprint review. And the institution has to implement all the recommendations that are made by the reviewer. And then also that show cause order. During that show cause period, any NCAA member school that wants to employ the former coach has to show cause why he should not have restrictions on athletically related activities. So it makes it harder for others to hire him as well. So really this decision showed how they focused on how head coaches are in a unique position of trust, and that prospects and student athletes and their parents will look to them to assist them in making decisions about what schools to attend. A critical factor is obviously the value of an athletics scholarship. The NCAA found that the head coach betrayed that trust, making this intentional misrepresentation. We can move on to the next slide. So Pat mentioned earlier what happened at Mercer University, but in short, an international prospective student athlete arrived on campus before enrolling, and the head coach of the women's cross country and track and field programs gave impermissible inducements to that prospect, which included free travel and housing, gear, tickets to other games. They conducted impermissible tryouts, and they exceeded the permissible number of recruiting opportunities. Here, the head coach was unable to rebut the presumption of responsibility due to both his personal involvement in the recruiting violations and his failure to report any potential impermissible actions by an assistant coach. So the head coach, he personally committed violations when he provided the prospect with tickets to 2 football games, and when he watched the prospect participate in impermissible tryouts on numerous occasions. But he also had problems with what the assistant coach was doing. And they mentioned that he had a general indifference to what the assistant coach and the team were doing when interacting with the prospect. Over the 2-month period, he never questioned the permissibility of the prospect's presence, participation, and engagement with his staff, players, and team. You can see there the quote from the decision was, he had a relaxed attitude toward compliance and an over delegation of responsibilities. So he's trying to push everything down to his assistant coach. Delegation in a lot of ways is a good thing, because you're giving people who report to you more control over what they do, more responsibility. But here he didn't maintain any oversight. And so he walked right into these penalties, unfortunately. Had a 1-year show cause order. They got suspended from 30% of contests. He has to go to a regional rules seminar, and he has to get monthly rules education. So that's what happened to the head coach at Mercer University. Again, you have problems because of his direct involvement, but also because of his lack of oversight. And that's why he failed to rebut it. So we've got 4 minutes left. I'm going to hand it back over, I believe, to Amy to wrap us up.
Thanks so much, Sandy. So for long-awaited CLE code number 2, that number is 12755. Again, that code is 12755. And so in our last couple of minutes, as you take a look at the CLE code before we move slides, we just, as introduced early on, wanted to sort of tie up these threads in what can we do? We've heard the bad stuff. We've heard how things can go wrong. What can I do, either as somebody who has sole responsibility for compliance, or as someone else in the institution that may, even if infrequently, intersect with our intercollegiate athletics program. So we've heard from Sandy and Pat that if we are an NCAA participating institution, and there are parallel obligations under other of our organizations, but to focus on NCAA, we have an affirmative obligation to monitor and control our athletics programs, the representatives of our athletics programs and our institutions, and our student athletes, to ensure compliance with NCAA constitution, bylaws, all of these rules we've been talking about. The complementary obligation is to report those instances of non-compliance. So what can we be doing? This last slide here will give you sort of a high level bullet point, and you can think of them because, hey, sports as both defensive and offensive measures we can take either on the front end and to be proactive, or if we are in a situation when perhaps we are reporting non-compliance or NCAA has come knocking to discuss what we've been doing. Some things to keep in mind here are the most important part of compliance, as many of you already know, is being proactive, doing a gut check on what's going on in our programs. How are we matching up against the rules? What can we do better in our processes? And as we've heard from both Pat and Sandy, train, 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 make sure that we are in touch with our athletics personnel, make sure that we are in touch with our faculty reps, and make sure that we are engaged through every level of our institution. The goal here is to set a culture and expectation of compliance with our rules. So we should be training and educating our staff, our boosters. Remember to include our boosters in these types of reminders about our rules. We want to maintain monitoring systems that are going to put us on alert if we start to slide outside of our guardrails, or if worst case scenario, we need to be making a report to NCAA. Keep up to date with those trends and those key issues that NCAA itself is reporting out. This will give you a really nice framework for thinking about your compliance programs. And if you are in a situation when you're either reporting or responding to potential infractions, sit down with your bylaws, sit down with the IOPs that Pat introduced, figure out what are the risks, where can we make some proactive steps to implement remedial measures, all in the spirit of being able to hopefully mitigate some of the outcomes of the infractions process. Consider, and we would be remiss as outside counsel to not say, consider engaging outside counsel if you are in a situation where you need to respond to an NCAA investigation. Much as in other situations, we want to be cognizant of the benefits of privilege and when we might want to assert privilege. On the front end, and just the last note in being proactive, whether you are engaging somebody outside of your institution or you are coming in with your own fresh eyes, consider doing an assessment of how things are working. When's the last time that folks were trained? Is there more or something different we can be doing to set that culture and expectation of compliance? There are so many options here. You'll have this slide in your materials. You'll have the slide that Pat, unfortunately, didn't get to dig into at too much length, but that lays out some really nice options for a compliance program. Respectful of all of your time, I will end there to thank you so much for participating today. If your question is still pending, we will do our best to follow up with you outside of this webinar context. Otherwise, please remember to keep an eye out for that thank you email. You'll have access to these materials as well as some other references that we think are helpful. And it will give you an opportunity to complete that all important CLE survey so you can get the credit that you all want so much. With that, thank you to all of you. Thank you to Pat and thank you to Sandy. And we hope to see you all soon.
Thanks, everybody.
Thanks for joining us. Take care.